My lords, pardon to mention,
But the judicial order of WPC number 55900/2019 will be listed on 30th September. It has not been listed.
Lordship, I want to mention an urgent matter. This matter was listed day before yesterday before your Lordship, wherein my Lord's notice was issued and it is fixed to 18th of November. But in the meantime, my Lords, the collector has already taken steps to evict the petitioner. I have immediately filed an IA, my Lord, seeking protection till next date of hearing.
Promotion matter of 2020, my lord. Promotion matter of 2020. Of a bench clerk, my lord, subordinate court staff.
The Honorable Court directed to list the matter on week commencing 4th November 2024. It has not been listed as because the similar matter has been disposed of by this Honorable Court.
Fresh admission matter, order against CAT.
And permission, my lord, press admission matter, land acquisition authority disbursement.
I beg your pardon, my lord. Item number 32. Mr. Kanungo just informed me that he has got some personal difficulties.
Is it press admission or?
No. It's a regular admission.
Is there
Afternoon.
no entry mode? You are for the petition?
No. We are for the petitioner. There is no entry order. It's challenging the state tribunal order.
32.
My lord.
Kanungo is for the petitioner.
Yes. Informally, he has got some personal difficulty. Let it come 2 weeks after, my lord.
You have 32. Because the other side is there. No. Entry order. You are to it. Yes.
Entry order some connected matter.
Maybe, but let it be there.
my lord, my lords, item number 27, সেটা wrongly type କରିଦେଇଥିଲେ ସେମାନେ order ରେ ସେଇଟା ଅଛି କିନ୍ତୁ ତା ସହିତ ଆଉ ଦିଟା ବି wrongly order ଟାକୁ type କରିଦେଇଛନ୍ତି petitioner ନାଁ
Date of the correction for the
24738
the dealing extent has pointed out that in this one. So, no?
ଆଉ ଦିଟା ଏକା ସାଙ୍ଗେ 24738
Abita list re nahi apna number diyantu.
24738
File memo. Yes. File memo. Yes, next.
Supplemental list, item number 1.
This is covered by Narottama Ratha's case.
This is order against
the settlement officer, annexure 4, which has been passed.
Page 27.
So, have you examined that judgment and
Yes.
Yes, I had seen
covered.
my lord. It's covered, but
Your Lordship's judgment order also.
It's all right.
but my lord, the impugned order is keeping in view the above issues. The suit property belongs to leased property. The undersigned asked the petitioner to produce relevant documents and maps proving the genuine transfer of their suit land in their favor. The petitioner has not produced relevant legal documents and maps to that effect, nor proved their possession over the suit property. Hence, the case is considered on merit, and prayer of the petitioner to maintain record in their favor is legally not maintainable and rejected. Let him go and produce the documents before him.
Produce the document.
No, my lord. That now I cannot produce before the settlement.
Not before the other authority.
My lord, it is a case where this has been quashed by this honorable court. Thereafter, they did not take.
When you are not producing the document, how
we cannot? It is not available with the Tahsil, my lord. Till date, they are not taking the decision because they are not. These documents, your lordship may call for the document. Your lordship will come to know that those documents are not available with the Tahsil. They are not searching for the documents of the leased documents.
You want in view of the salary dated 2780.
Yes, ma'am. Yes, ma'am.
This particular plot should be recorded
in my name.
Now you come to that annexure 4.
Yes, ma'am.
Which you are challenging, and the London State Council place the relevant parts.
Yes, ma'am.
That keeping in view the above issues, the suit property being the leased property.
Yes, ma'am.
the undersigned asks the petitioner to produce the relevant documents
Yes, my lord.
and maps
Yes, my lord.
approving the genuine transfer.
Yes, my
of
lord.
the
We have
suit land in their
submitted
favor.
our cell deed and other documents, my lord. The order passed by the honorable
Just a
court
minute.
earlier,
Petitioner,
my lord.
Just a minute. The
My
petitioner has not produced the relevant legal documents and maps to that effect, nor proved their position over the suit property. And the case is considered on merit and fair. So yes, you have not produced all these
My lord,
documents.
that we have given our cell deed as well as the all documents, my lord.
You have not only you have filed
And this
here
is
only for
the
cell deed.
format order in all cases it has been passed, my lord.
We are not going to
Yes,
that
ma'am.
format order.
Yes, ma'am.
The
Your lordship,
ordinance-
directly I will appear before the settlement officer Jobra, my lord, and produce all relevant document with me.
As is directed in the order.
My lord.
As is directed in the order.
The learned counsel for this writ petition has been filed by the petitioner Sandhyarani Hota with a prayer to quash the order dated when that order was passed.
My lord.
30 series କେତେଟା ଲେଖା ହେଇଛି? 32 2013
ଆଜ୍ଞା
32 2013
33 2013 my lord.
33 2013 passed by the assistant settlement officer in objection case number 9906/622 of 2012 with a further prayer for a direction to the opposite parties to record the land to hide Hal plot number 3254, Hal Khata number 2737, corresponding to Savi Khata number 647/1682, Khata number 325/90 in the name of the petitioner as per cell deed dated 2/7/1984. From the impugned order, it appears that the assistant settlement officer has been pleased to hold that the suit property being leased property, he asks the petitioner to produce the relevant documents and maps proving the genuine transfer of the suit land in his favor. However, the petitioner could not produce the relevant legal documents and maps to that effect, nor prove his possession over the suit property. Accordingly, the case was considered on merit, and the prayer of the petitioner to maintain the record in her name was held to be not legally maintainable and rejected. The learned counsel for the petitioner placed reliance in the case of Narottam Rath versus State of Odisha in WPC number 1608 of 2014, which was disposed of along with a batch of petitions. And what is the question framed in that case?
My lord. Page 46.
46.
19. Direction person.
No. 46.
Yes, there also the records are there.
Just a minute.
Yes, ma'am. 19.
Page 46, paragraph 19.
Again.
Wherein the following directions were issued. Quote all these directions. The learned counsel for the petitioner submitted that since the impugned order of the ASO by Annexure 4 declining to accept the request of the petitioner for recording her name in the ROR in respect of the land in question on the ground that the land belonged to government was set aside this order is also not sustainable in the eye of law. However, in the said case, it appears that the direction was issued to ASO to proceed to record the names of the respective petitioner concerned the land in question in their names in the ROR in accordance with law within a period of 8 weeks. With a further direction that where the land in question stood recorded in the final published ROR in the name of the government, that entry will stand cancelled by virtue of the order passed, and the ASO will proceed to record it in favor of the respective petitioner. The land counsel for the petitioner submits that the petitioner has got all the relevant documents with her, and she can produce before the concerned authority, and therefore the same may be taken into account, keeping in view the observation made in the case of Narottam Rath versus State of Orissa. The land counsel for the state, though placed the impugned order under Annexure 4, but submitted that if the petitioner produces the documents as required for recording her name in the ROR, there may not be any difficulty on the part of the authority to record the name of the petitioner in the ROR. Accordingly, the writ petition is disposed of with observation that if within a period of how many days you will produce the documents?
Within 15 days, madam.
We are giving you 4 weeks time. Within a period of 4 weeks, if the petitioner produces all the documents before the concerned authority, the authority will take into account those documents in accordance with law and keep in view the observation made in the case of so and so, and pass necessary orders in accordance with law. Accordingly, the writ petition is disposed of. Yes,
My opposite party number
time টা করে নেয়।
5, my lord.
5. সেটা opposite party number 5 for you.
And this time may be framed
Necessary order within 2 months thereafter.
apply.
মানে মাসের ভিতরে shift করে দিতে হবে 2 months thereafter.
Apply. Second time, sir.
Same.
সেটা খালি হি হবো সেই
Second regency है तो
আগে সব
second টাতে কি লিখবে?
এই কোর্টে ফ্যামিলি।
Yes, next.
Item 3.
Yes, what is it, Rehan?
No, my
Item 4. Adamant, if case number is different, it is mentioned in the paragraph 1.
That will be there.
Man, paragraph 1.
That will be taken care. So, three pass over to Kenan.
Item number 4.
May I please? Madam, the matter relates to the land acquisition under the National Highway. There is a arbitration proceeding which has been award has been passed by annexure 4 Miller, and the running page is 22. And the operating portion is that the direction was made to the LO and the opposite party number 1.
Please come to that operating portion.
Yes,
Please use that. Bakam is there and he is there to assist you. Please use it.
Paragraph number 4 Miller at page number 22.
Gone through the case record.
Gone through the
Please
case.
read it out.
Gone through the case record along with the written submission of the parties and the documents as available in the case record. It is ascertained that the value of the land has been properly determined, but the multiplication factor of village Neurapur for radial distance is to be 1.4 instead of 1.2, as it is 24.96 km from the nearest urban area. Further, the area of the structure has been cross-checked and found some discrepancy with the previous measurements. So the petitioner is entitled to receive his compensation amount accordingly. Hence, the opposite parties are directed to recalculate the award amount and payment may be made to the petitioners accordingly as per the provisions of the LA Act after deduction of the amount paid earlier. This is the operating portion.
Opposite parties means who are the opposite party?
Opposite parties number 1 and 2 here in this case.
Okay. They were directed. So what
They were
happened
directed.
thereafter? This order was passed in 28/12/2020.
Yes, Miller. Thereafter, Miller, the opposite party number 2, the LO recalculated the compensation amount by annexure 1, Miller.
Yeah.
And your lordship may kindly see the running page number 11. At column number 14, Miller.
Column number 14, yes.
There is a 12% interest per annum, additional market value. And my lord, they have calculated the interest on the land only, but they have not calculated on the structure. But the notification says that it is on both. That is under annexure 2, Miller, at page number 13.
Interest at the rate of 12% per annum shall be applicable on the market value for land and structure.
Yes, Miller.
From the date. So this calculation is only for the land.
Only for the land, Miller.
Sure.
Thereafter, I filed a petition before the learned arbitrator, and the arbitrator didn't entertain on the plea that the order has already.
Say order kind.
So to say order passed kalangi entertain.
Where is that application?
That is under annexure 3, Miller.
Before the collector come arbitrate.
So
that is pending.
No, he said that he has. Is it sub judice or decided? Or you have
he has not passed any order and
he has
when
not
place this matter before the learned arbitrator.
Instruction, Mr. State Counsel.
My lord.
He advised me, Lord, to file a grievance petition. Thereafter also the petitioner filed a grievance petition.
Just take instruction whether this application which has been filed by annexure 3, because there was some kind of wrong calculation, whether he has brought it to the notice of the collector by filing a petition, whether any order has been passed on annexure 3 or not.
Yes.
That's what you want.
But it is for NHI.
In this manner.
Though,
Mr.
National.
Achha, then Mr. Das, you are to do it now.
Yeah.
Honorable Collector come arbitrator Jajpur, Odisha. It's a national highway matter.
National.
So, have you served a copy on Mr. Das?
I have served only to the Union of India.
No.
I'll serve it.
All right. Let a copy of the
matter has been pending, my lord.
Yes, it is pending.
It is pending before the arbitrator.
Yes.
Then it's all right, my lord. If it is disposed
of
by the
No. It is pending.
That he has filed a petition on 29/4/2024 before the
Arbitrator
authority comes. So that is no communication has been made. So he is not aware. So you can take instruction for that.
Okay, any order passed after the
Could you follow?
passed by the
Mr. Das, could you follow his submission? His submission is that because the LA authority had not properly calculated, he moved before the arbitrator, collector. And collector also found that there is some discrepancy in the calculation. So he directed the LA authority to recalculate and pay him the compensation. Recalculation was made, but not in accordance with the direction.
Right.
So that is how he again moved the arbitrator. So that is pending.
So just take instruction. If any order has been passed, it is well and good. It should have been communicated to him. If it is not passed, I will ask him to pass the necessary order within a time stipulated. So that.
I beg pardon, my lord, no order has been passed.
All right, that is how.
Yes.
Let a copy of the writ petition be served on Mr. Amitav Das, who is to appear for opposite party number 2. The competent authority from land acquisition officer, that will be NH. The land and counsel for the petitioner drew the attention of the court to the award passed by the collector Jaspur, opposite party number
3.
3 on 28/12/2023, wherein it has been held as follows. Quote this from page number 22. Gone through the case record to up to accordingly the case disposed of. Say present the land counsel for the petitioner submitted that in pursuance of such order, the though the calculation was made
High OP2
by opposite party number 2, but it was not made in accordance with the notification
under Annexure 2.
under Annexure 2, and for which he filed a petition before the opposite party number 2, which has been registered as arbitration miscase number 18 of 2020.
Yes, ma'am. That is opposite party number 3, ma'am.
Opposite party number 3, yes, 2. Opposite party, and it is filed on 29/4/2024. But he is yet to receive any instruction, any order from the opposite party number 3, and the miscase. It is his instruction that the miscase is still sub judice. Mr. Amitav Das, land counsel, took some time to obtain instruction about the status of arbitration miscase number 18 of 2020. Give him a copy, and it will be listed in the week commencing from 25th. It will on 25th of November 2024. The name of Mr. Das will be reflected in the cause list. Okay. Copy of the. Copy.
My lord, appearance of Union of India may be kindly be noted.
Union of India.
My lord, we are there for OP number 1, my lord.
Yeah, or Mr. Bani ko naam lekhi debe.
Deepak Gochait, my lord. Deepak Gochait, CGC.
Yes.
Obliged.
Item 5.
Item 5. Your lordship wanted to know position of the appeal. Certificate of has not been supplied, so there is some more time.
You want some more time? Land counsel for the petition, they have received communication from the state manager so and so that the representation filed by them have been disposed of on so and so by the competent in accordance with law. And he further to the attention of this court that against this order passed in so and so. RFA is pending in the Court of Law and Judge Junior Division. However, when a query is met regarding the status of the case, one counsel for the petition submitted he shall obtain the order sheet of the case and file it. So you are seeking some more time for correct. The land counsel for the petitioner seeks some more time to comply the order dated, to comply, to produce the order sheet of civil suit number 38.
Number, RFA number.
RFA is 19 of 24.
RFA number 19 of
But that is not
2024.
pending before the
It
civil judge,
cannot be
junior division.
junior division.
How can it be before the
district judge has to.
district judge? Sir, भूल
That
गए थे, हमारे
is
lecture में.
RFA number 19 of 2024, which is pending in the court of London
District
district judge.
District
Norma
judge.
Jharsuguda.
Okay.
ठीक तो?
Hmm.
नंबर ठीक है तो RFA number 19 of 2024. है ना? तो 25 तारीख रे आसीबो. All right.
Item 6.
I beg apology, my lord. On behalf of learned DSJ, my lord, we pray for adjournment as Mrs. Jyotsna Sahu has resigned from the post of CGC, my lord.
Jyotsna Sahu has resigned.
My lord, she has joined as ASC, my lord.
No, it's all right. So somebody else has to be assigned this case.
My lord.
All right. We are mentioning Mr. Paddy's name that
My lord.
a mention is made on behalf of Mr. Paddy and Deputy Solicitor General of India that earlier the case was entrusted to Mrs. Jyotsna Sahu. However, since he has joined the government panel, state government panel, DAG office, therefore somebody else is to be assigned this matter, and therefore the matter will adjourn. Put up this matter will be commencing from 25th. Yes.
Obligement.
Item 7.
May I please, Your Lordship? Here in this writ application, the petitioner seeking for a direction to the opposite party to provide regular employment in NINL as the petitioner is a land loser and displaced person of Kalinganagar Industrial Estate Miller. Initially, the petitioner approached this honorable court and this honorable court under Annex 5 Miller at page 25 passed an order directing the opposite party number 4 to take a decision on the reprehension of the petitioner, claiming appointment under Rehabilitation Assistance Scheme Miller. But the authorities concerned disposed of my reprehension under Annex 6 series, my lord. If your lordship will turn to page 27, your lordship will find my reprehension was rejected by the learned sub-collector, special land acquisition of Kalinganagar on the ground that ADM, I am not entitled to get the benefit under the RR scheme as per the policy of the 2005 Miller. If your lordship will turn
just a minute. This is order dated 6/6/23.
Yes, my lords.
Gone through the RR policy 2006, which is not applicable to Kalinganagar Industrial Complex of Jaspur District. The
Yes.
RR guideline 2005 published and approved guidelines regulating
rehabilitation and resettlement of families, persons displaced, affected.
providing so and so. So, according to what is your submission?
My submission is I am entitled to get as per the policy of 2005 Miller. If your lordship will turn to Annex 2, the policy itself I have annexed.
The policy was in 2005 and 2006 also.
Yes, my lord.
So you are in 2000, not in 6.
No, my lord. I am in 2005. I'm entitled under the scheme of 2005.
Guideline 2005.
2005, 2006. Both the guidelines are applicable to me. And even the Learned Court has considered my application under 2005 guideline. And 2005 guideline.
Even 2005 guideline you are entitled.
Yes, ma'am. If your lordship turn to page 18, clause 5 Miller, procedure for providing employment, self-employment.
Page 18 of what?
That Annexure 2.
Annexure 2.
Annexure 2.
Page 18.
Right.
Procedure for providing employment, self-employment. Permanent resident of Orissa shall be given preference by the company for employment, self-employment. The company is setting up the industrial project at Kalinganagar will have to give preference to the nominated one member of each displaced family in providing employment either in industry or in ancillary unit of the following order of preference. So what are the preference? Preference are 4 types of preference are there. And I am coming under the other displaced families. But if your lordship will turn to Annex 6 series, your lordship will find he has not mentioned category D Miller. While rejecting my claim, the Learned Court ADM has failed to take into consideration that I am also coming under clause D. If the lordship will again turn to page 27, my rejection. Employment, self-employment as follows. Families losing all land, including homestead. In I, displaced families losing land, including homestead land. In B, families losing more than 2/3 of land and homestead land. C, families losing more than 1/3 land and homestead land. And D is there. But at page 18, other displaced families. I am coming under other displaced families. But the learned ADM, without considering the fact, mechanically rejected my representation, disallowing me to get an suitable appointment.
Other displaced family definition kona?
Yes, madam. Other displaced families, those who have lose their only homestead land, madam.
Only homestead. So here it is agricultural land.
Agricultural land and other land also.
Right.
I'm getting.
As the agricultural land of the petitioner's family has been acquired,
yes,
and
madam.
compensation has already been paid,
at page
the question of employment.
Yes, madam. At page 27, people lordship turn to the last line. All the land of the family has been acquired. Here in this case, all my land has been acquired.
That must include the homestead land.
I got no homestead land, but
4 question. ये जो 18 पेज रो 4 question to केमिति determine हबो displaced family. आपण जो कहउछन ना other displaced family.
Yes, my lord.
से कहउछन a family or a person shall be considered to have been displaced and will be eligible for rehabilitation.
Yes, all the land of the family has been acquired. More than 1/3 land.
को category आछन हमु कोन.
I'm coming under category A, Miller. All the land of the family has been acquired. And in my case, all my land have been acquired under Annexure 1, Miller. If your lordship will turn to Annexure 1, though it is not in the status of Ghoravari, but all my lands
have you
around
taken that government in your petition? That I am coming within this, and in spite of that,
yes, my lord.
Sorry.
At page 7, Millers. In clause 5 of the said notification, though it has been specifically mentioned that other distressed family and also entitled for employment, the clause 5 of the said notification is quoted herewith for better appreciation of this honorable court. Procedure for providing employment, self-employment. For an resident of Orissa, displaced families losing all land, including homestead land.
No, you have just quoted down. You
Yes,
have not.
Your case?
Your case should is आपण जो आणुचंती ना other displaced family भीतर आसुचंती बोली से displaced family रो definition ता पूर्वरु दिया है जोटा को आपण केमिति ता भीतर आसीबे सेटा को हमहु बुझान
सेटा all the landlords all my
you should have taken that averment in your petition that since I have lost all the land, therefore I fulfill the criteria of a displaced family.
Other
displaced family. Therefore, this so and so should not have rejected my claim.
So my inspection, all my land in respect to that. Have you filed the notification showing entire land to have been acquired?
No, my lord.
Then how will you satisfy? You must satisfy the court showing that the total number of plots or agricultural land is this, and the entire land have been acquired.
As your lordship know, we are ST persons, and the land were acquired in the year 1991. And
take instruction from your client, if necessary, amend your petition.
Yes,
take proper instruction, because displaced families definition is there. Unless you fulfill that criteria, you cannot come within that other displaced family. Displaced family
since all my lands have been acquired by
government ନେଇଛନ୍ତି ନା କିଛି document ଦେଇଛନ୍ତି ସେଥିପାଇଁ
document annexure 1 document ଦେଇଛି ସବୁ ଯାକ
annexure 1 is what?
Annexure 1 is my land which has been acquired by the government.
ଏଥିରୁ କିଛି ଜଣା ପଡିବନି ଯେ ଆପଣଙ୍କର ସବୁ ତକ land ଆପଣଙ୍କର acquired ହେଲା ବୋଲି ଏଇଟା ଗୋଟେ just ଆପଣ
ଏଟା ଗୋଟେ ହାତରେ ଆପଣ ଲେଖିକି ଦେଇଛନ୍ତି where is the notification of the notification ଆପଣ ହାତରେ ଲେଖି ଦେଇଛନ୍ତି ଦେଖିଲେ
No, sir, this is the document provided by my client. I have not.
No, no, that is not required.
ସେଥିପାଇଁ ତ ଆମେ ଦଉଛୁ
ଆଜ୍ଞା।
ଆପଣଙ୍କୁ ଅପରଚ୍ୟୁନିଟି ଦଉଛୁ ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ନିଅନ୍ତୁ ଯେ
Uh,
ଆପଣ ଯୋଉ କହୁଛନ୍ତି
In the
ଯେ
meantime,
ସବୁତକ ଲ୍ୟାଣ୍ଡ
I
ଆକ୍ୱାର କରିଦେଇଛନ୍ତି
I'll file a
that is
modification application to that effect. Let the government in the meantime take instruction.
ଗଭର୍ଣ୍ଣମେଣ୍ଟ କେମିତି ନବ ଆପଣ ଆଭରମେଣ୍ଟ
Whether
ନା ତାଙ୍କୁ କହିବି ଆମେ କାଉଣ୍ଟର ଫାଇଲ କରିବା ସେ କଣ କାଉଣ୍ଟର ଫାଇଲ କରିବେ ଆପଣଙ୍କର ତ କେସ୍ ଟା ବେସ୍ ତିଆରି ହେଲେ ସିନା ସେ ଗୋଟେ ଇଏ ହୁଏ ଆପଣ ଯୋଉ ବେସ୍ ରେ ନଉଛନ୍ତି ସେ ବେସ୍ ପାଇଁ ମ୍ୟାଟେରିଆଲ ହିଁ ନାହିଁ ଆପଣଙ୍କର ଫାଉଣ୍ଡେସନ ଇଜ ଅଲରେଡି ସେକି because you have not taken the specific averments which are necessary to be taken for the claim.
That apart, my lord, you should make party to Tata Steels Limited. And
Tata
give
Steel
them
Limited is
appointment.
yes, ma'am. Tata.
All right, this writ petition, we are giving you time to make take instruction. This writ petition has been filed by the petitioner Sridhar Mahara with a prayer
Still couldn't do the appointment.
for a direction to the opposite parties to provide him regular employment in Kalinganagar integrated
Then I
industrial
may be
complex.
permitted to withdraw the writ application
Alright.
with liberty to
The
file a
learned
better
counsel
application.
for the petitioner seeks permission to withdraw the application to file a better or to file another writ petition with better particulars. Writ petition is disposed of as we give him liberty to the petitioner. Yes.
Obliged.
Item 8.
Item 8 may lie before 1 week after mail.
Mr. C.DASH, learned counsel appearing for the petitioners seeks for an adjournment. Place this matter on 25th of November 2024.
Item 9.
May I please, madam? Yes, I have a challenge matter annex number 7, which has been passed by the appellate authority, the concerned district officer, without giving me an opportunity of hearing, and also while sitting over to decide the matter, based on the report of the other authorities, he has closed the hearing. The fact remains in the year 2000, a lease was granted in my favor, and I continued the same. I paid the lease premium, and it continued for 2021. In the year 2021, by annex number 1, so that annex number 2, I received a notice of show cause issued by the concerned state officer, thereby directing me and holding me to be a unauthorized occupant. Whereas, by virtue of a lease deed, I am continuing as a by paying the lease premium, and I also paid the lease amount to the concerned authorities. But I have been addressed as an unauthorized occupant, and with that capacity, I have been asked for show cause. By annex number 3, I have issued by show cause. Well, I have said I am not an unauthorized occupant. I am a leaseholder, and I am paying the lease premium regularly, and I have not violated anything. But I am entitled to hold the ballot things in my favor. Thereafter, when I filed this show cause, and whereupon they found that I am a leaseholder, so certainly the ballot state officer asked for a show cause by annex number 4 from the authorities to meet my queries ballot. They have not given any show cause. By annex number 5, again reminder was issued. Now, annex number 6, when I approach the authorities, they have misbehaved. So I file a application with the authorities that I have been misbehaved. The moment they got ballot, now they have intimidated that we have already evicted the concerned person. We have closed we have taken up to that particular land into our custody. And according to the inquiry which was proposed or initiated on my against me on the allegation that I am not occupied, that is in closed ballot, annex number 7. When you are asking me,
from that annexure 7, which you are challenging,
annex number 7, page my lord, it is just 29. But can have a class.
Yeah.
The case is taken up today.
Yeah.
Received letter number such and such from divisional head at IDCO Barampur division, wherein the divisional head IDCO Barampur reported that the opposite party has been evicted from the IDCO plot number such and such. Barampur on dated 6/8/2024, physical possession has been taken over by IDCO authority and requested to close the OPP case. Hence, the OPP case is closed, my lord. Intimated concern, my lord.
So, are you disputing this?
Yes, my lord. Till that it is in my possession. First,
you have been evicted.
My lord.
Are you disputing it?
Yes, my lord. Yes, my lord. I am still in possession, my lord. And
where have you stated?
My lord.
that the letter dated 9/8/2024 from the divisional head,
Madam.
which contains that you have been evicted from the plot number so and so, is a wrong statement. In fact, you are still in possession of that plot.
Yes, sir. Para 10 minute I've said so.
Para
10 again.
10.
Again. That the person humbly submit that he has admittedly a so cause in such and such that in reply to such special taken a stand that he has utilized the leased plot as a service unit for vehicle and to counter the same, the opposite part number 2 such and such has asked for a clarification such and such. The has from the opposite part number 1, but the same was not responded as is evident from an such and such, for which hearing of such and such, and based on the without further ado, the dispute to ascertain the reasons of initiation of proceeding, final order to drop the proceeding without affording opportunity of such and such has been given, my lord.
No, that is not taken, Mr. John.
My lord.
If you want to take, you can take. Otherwise, your remedy lies elsewhere.
No, my lord, I don't dispute it because appeal is there. I am not on that, my lord. My humble submission kindly appreciate. That's why I have come before this honorable court, because the case has, the case has been initiated against me. I have been directed to file my show cause.
Yes.
So before the show cause was taken off or any hearing was there, they simply close the proceeding. It is just like a case where I have been asked for to file my response by whether your bail will be cancelled or not. But before that, all such things will close, my lord. I have the concerned person taken custody, my lord. My humble submission, my lord. My lord, may have a glance to Annex 4 and 5, my lord. That will suffice, my lord. Annex 4 and 5. I pray, my lord, to have a glance. It's a small one, my lord. Page it is 25, my lord. They have initiated the proceeding with under 4A.
Why the show cause was issued? Just
my lord. Then my lord may turn to annexure 2, my lord.
Yeah.
May I please it, my lord?
Yes.
The first one. Whereas I am the undersigned and of the opinion that you are a unauthorized occupant of the public premises mentioned in this schedule below, and that you should be evicted of the said premises of the following grounds. On the following grounds, the grounds number 1, the divisional head such and such, letter number such and such, is the owner of the IDCO plot number such and such, area such and such, and you have unauthorizedly occupied the IDCO plot as mentioned in this schedule below, my lord. So they have said that I have unauthorizedly occupied, my lord. First ground. Second, you have occupied the such and such, which
without vacating the same
my lord,
date.
my lord. And now, therefore,
see the date particular. The case is posted to 22/6/2021 at 11 a.m. in my chamber at IDCO.
My lord.
So you are noticed to
my
appear.
Lord. My lord,
What happened then?
My lord, bear me for a moment at the present juncture, my lord. So I have been addressed as an unauthorized occupant of the particular land, my lord.
Yes.
So before that, my lord, I pray my lord to have a glance to Annex 1.
All right, you say that you are a lazy. All right.
My lord. Then my lord may turn to page. My lord may page the next page to my lord Annex 3, my lord.
Yes.
Where I have submitted my show cause.
In 2023, sir.
My lord.
After 2 years.
No. It's a continuation, my lord.
Where is that? On date.
Pardon?
On 22nd, 6, 2021, what happened?
What happened?
My lord, I have appeared because the court was not there. And my lord, then just to get my lord police, my lord, but turn to page annexure 4. In response to my show cause, which I have filed, which I have placed, which my lord has kind enough to gone through annexure 3, they have accepted my show cause.
My lord. The state officer must be maintaining a file. These numbers are there. The order sheet must have been mentioned. कारण आपन जेतले notice कले आपनकर डेट पकेले 22/6/2021 आपन obviously से दिन बोधे appear करना
नहीं what happened, my lord, regular procedure हुए नहीं कोर्ट टा करंती not a regular process, my lord. just
When-
my lord query my lord
ପକେଇଲେ ଆମେ ତିନିଟାରେ
I-
ଉଠିଯିବୁ ସେଟା କଣ ନେବେ?
no, I am duty bound to give an answer to my lord's query. Just have a glance to answer 4, my lord, get my lord's answer. Because my so cause was on 23, I do consider my lord, annex number 3. Then what is there, my lord, whether they have taken consideration or not, my lord, just have a glance to annex 4. My query, my so cause was on 26, 2023, my lord. Then they have accepted it, and because of the fact that it was in their mind, in the mind of the concerned court, that I am an unauthorized occupant, but the moment I file all those documents, list document, they now turn their voice and they have said that give a response because I am a leaseholder. And it's 4, my lord, page 25. My God, may I place it, my lord?
Just a minute.
My lord.
You come to annexure
My lord.
annexure 4, which is dated 17/11/23.
My lord.
This order was passed by state officer.
My lord.
That shows that by that date also your case was pending.
My lord.
And the divisional head of ITCO, a report was submitted by him in which he mentions that the divisional head mentioned in his report, that is second subpara,
My lord.
along with photograph, that the land is lying vacant and there is no industrial activity on the allotted land. Ask the divisional head ITCO to report compliance by 5/1/24.
My lord.
Opposite party to remain present on the next date he hearing.
Myself.
Okay. So then 5/1/2024 ରେ ରହିଲା. So
Right.
ultimately
ତାପରଟା my lord, may see annexure 5 again. This is continue. It was continue. Not that it is the proceeding has been closed. my lord.
ସେଇଥିପାଇଁ
ଆଜ୍ଞା,
ତ
annexure
ତାପରେ
5.
ଆପଣଙ୍କର ଡେଟ୍ ହେଲା so and so
26
is present and receive the divisional head view. No report has been received. Asha. OP is directed to remain present in court. Ask the divisional to remain present on the court specific case posted to 26/4/2024
Right.
in my chamber.
Right.
Then what happened?
My lord.
You filed
Then, my lord, thereafter, my lord, I have made a complaint before the concerned authorities that they have misbehaved in also in annex number 6. That is on 26/6/2024.
Yes.
My lord. Then I pray. Then the last order is this, my lord. Annexure 7, my lord. So the proceeding was pending. So before it was fully adjudicated, based on the report of the concerned base level authority that they have taken possession of the land, they have closed it, my lord. Then what was the necessity of this entire process of hearing, my lord? So my humble submission, I have not been given opportunity, and I am not an unauthorized occupant. I am a leaseholder, and now what is their case? And the lease was granted upon the ground that it requires some sort of automobile activities, my lord.
On 5/9/2024.
My lord.
Whether the date was fixed to that day or not.
It was fixed, my lord.
Then why did you appear
No.
on that day?
My
ସବୁ ଡେଟ୍ ରେ ତ ସିଏ କହୁଛନ୍ତି ନା ଅମକ ତାରିଖରେ କେସ୍ ଏଇ ସମୟରେ ଟେକ୍ ଅଫ୍ ହବ ଏବଂ କେସ୍ ଲେଖୁଛନ୍ତି ସେ କେସ୍ ପୋଷ୍ଟେଡ ଟୁ ଆପଣଙ୍କ ପ୍ରେଜେନ୍ସ ରେ ଅର୍ଡର ପାସ୍ ହଉଛି ତେଣୁ ଯୋଉ ଦିନ ସେ ଅର୍ଡର ପାସ୍ କଲେ ସେଇଟା ହଉଛି 5/9/2024 ରେ ସେଦିନ ଆପଣ ଅନୁପସ୍ଥିତ ନଥିଲେ ତ 5/9/2024 ରେ ନିଶ୍ଚୟ ଗୋଟେ ତାରିଖ ଧାର୍ଯ୍ୟ ହେଇଥିବ ଯୋଉଥିପାଇଁ ଆପଣ ଉପସ୍ଥିତ ରହିଲେନି ତେଣୁ ସିଏ କେସ୍ ଟାକୁ ସେଦିନ ଡିସପୋଜ କଲେ
ସେଦିନ my lord, may see the order itself, my lord. The case is taken up today, received letter such and such closed.
Now, have you taken any averment that on 5/9/2024 the date was not fixed and you are not aware about that date? That is why you could not remain present and behind your back this order has been passed.
That part, my lord, with all respect, because my humble service can't help you.
Make out karibe
No, more
my କହୁଛନ୍ତି ମତେ ପ୍ରିନ୍ସିପଲ ଅଫ ନ୍ୟାଚୁରାଲ ଜଷ୍ଟିସ ଫଲୋ ହେଇନି ମତେ ନ ଶୁଣିକିନି ଅର୍ଡର ଟା
arbitrarily, my lord, may see
ପାଇଁ ଯୋଉ ବେସ୍ ଗୁଡାକ ଆଣିବା କଥା 5/9/2000 ସବୁଦିନ ଆମେ ଦେଖୁଛୁ ଯେତିକ ତାରିଖ ଆପଣ ଦେଲେଣି ସବୁଦିନ ଆପଣଙ୍କ ପ୍ରେଜେନ୍ସ ରେ ଡେଟ୍ ଫିକ୍ସ ହଉଛି ତେଣୁ ଯଦି ଗୋଟେ ଡେଟ୍ ଟା 5/9/2024 କୁ ଅଛି ଶୁଣାଣି ପାଇଁ ଆପଣ ସେଦିନ ଅନୁପସ୍ଥିତ ରହିଲେ ସେଦିନ ଗୋଟେ ରିପୋର୍ଟ ଆସିଲା ଯେ ଆପଣଙ୍କୁ ଅଲରେଡି ଏଭିକ୍ସନ ହେଇସାରିଲାଣି 6/8/2024 ରୁ। ତେଣୁ ସେ ଅର୍ଡର ପାସ୍ କରି କେସ୍ ଟାକୁ କ୍ଲୋଜ କରିଦେଲେ। ତ 5/9/2024 ପୂର୍ବରୁ କେବେ ଡେଟ୍ ଥିଲା ଆପଣଙ୍କର?
ଆଉ ଡେଟ୍ ଆଜ୍ଞା ହେଇନି, ସେ ଲାଷ୍ଟ ଆନେକ୍ସର ନମ୍ବର 5 ମେଲର। ଆନେକ୍ସର 5 ହଉଛି ଲାଷ୍ଟ ଡେଟ୍। 26/4 ଥିଲା। 26/4
କିଛି
କିଛି ହେଲାନି, so he has not there।
ଏଗୁଡାକ ପାଇଁ ଗଭର୍ନମେଣ୍ଟ ନବା ଦରକାର। ଆପଣ ପ୍ରୋବ୍ଲେମ ହଉଛି ସେଇଆ।
और मे पे
ନ୍ୟାଚୁରାଲ ଜଷ୍ଟିସ ଆଇନା ମାନେ ତାକୁ ବେସ୍ କରିକି ନବାକୁ ଇଏ ପଡିବ। ଆପଣ କୋଉ ନେଇଛନ୍ତି ସେମିତି ସେ 24 ପରେ ଆଉ କିଛି
my humble submission, the case has been initiated against me, my lord. Rightly, wrongly, they have initiated, my lord. They are my authority, or the law permits, they have been initiated, my lord. Firstly, they have, my lord, made a wrong, my lord, address to me that I am a unauthorized occupant. Whatever it may, my lord. Now I am admittedly a leaseholder, no doubt about it. And secondly, my lord, and admittedly, my lord, they have initiated a case. All right. My lord, my humble submission, my lord, without giving an opportunity of hearing, they have closed the things because of the, and before the case was closed or before this particular proceeding was closed, they have, my lord, taken a, they have evicted me, my lord.
So, Mr. We are asking you a plain and simple question. ଗୋଟେ ଡେଟ୍ ମଧ୍ୟଙ୍କର ଧାର୍ଯ୍ୟ ହେଇଛି ଶୁଣାଣି ପାଇଁ। ଆପଣ ଅନୁପସ୍ଥିତ ରହିଲେ, ସେ କଣ କିଛି ଷ୍ଟେପ ନେଲେନି, ସେ କଣ କରିବ? ଯୋଉ ଅପର ପକ୍ଷ ଡକୁମେଣ୍ଟ ଫାଇଲ କରୁଛନ୍ତି, ଇଏ କରୁଛନ୍ତି, ଆପଣ ତରଫରୁ କିଛି ଷ୍ଟେପ ନାହିଁ, ତାହେଲେ ସେ କଣ କେସ୍ ଟାକୁ ପୁଣି ଯେ ନାଇଁ ଆସିବେ କାଳେ ଆଉ ଗୋଟେ ଡେଟ୍ ତାରିଖ ଘୁଞ୍ଚେଇ
2021-2024 ଚାଲିଲା, ତ ଗୋଟେ ଡେଟ୍ ପାଇଁ and or may pay, my lord, give me one opportunity, I'll file a detail of the date.
That would be better. File that
I'll
so that the
yes, ma'am, yes,
to 5/9/2024 the date was not
enter
fixed. That would be better. This writ petition has been filed by petitioner C.DASH with a prayer for quashing the order dated 5/9/2024 passed by the state officer. कितने नंबर opposite party?
Opposite party में क्या? This opposite party.
State officer.
Two, madam.
Opposite party number 2. In closing the OPP case, basing on the report received from the divisional head IDCO Berhampur division, wherein it has been mentioned that the petitioner has been evicted from IDCO plot number 22 by A of Autonagar, phase 1, Pradya Padar, Berhampur on 6/8/2024, physical possession has been taken over by the IDCO authority. Land counsel for the petitioner submitted that when the petitioner received the show cause notice on 24/5/2021, he filed his show cause and thereafter he was regularly taking steps. But on the relevant date when the impugned order was passed, the petitioner has not been afforded any opportunity of hearing, and this order suffers from non-compliance of the principle of natural justice and is not sustainable in the eye of law. At this stage, he seeks some time to produce the entire order sheet of the estate officer IDCO, put up this matter in the week commencing from Keberatiopon.
3 weeks after.
2 weeks after.
3 again, 3 weeks
after. Put up this matter in the week commencing from 2nd December 2020. Yes.
Item number 10.
I pray, kindly taken up next week. Already my government friend is appearing. I already sought the copy for the.
I have already received by virtue of my lord's order, and I have already filed my vocalatnama.
You are for the petitioner.
Yes, madam.
Where is your Vinama?
My lord, I have already filed on 30th, my lord.
Kanar Vinama Chikoila?
Nirmal Ranjan Rautray.
Yes. Particular. Nirmal Ranjan Rautwal. Mr. Nirmal Ranjan Rautwal and counsel submits that he has filed wakalatnama for the opposite party number 1,
So, my lord,
Gopal Chandra Naik.
Gopal Chandra Naik.
Opposite party number 1, Gopal Chandra Naik. At the registry place, the Vinama record. The name of the land and council be reflected in the cause list. Mr. Vishwajit Maharana, land council, appearing for the Union of India. We can mention it as central government council,
Yes.
central government council appearing for the petitioners for them. 6 for an adjournment till next week. Raise this matter on 11th of November 2020. Yes.
Item 11.
Item 11, my lords had directed me to verify whether the impugned order is covered by the Narottam Ratha judgment. It is, my lord, it is wholly utilized. That's right. But my lord, may I kindly have a look at the pleadings at page 3, para 3.
Page 3, para 3 of
My
the
of the writ petition.
writ petition.
My
Yes.
The second sentence, my lord, says, in the year 1974, the land was leased out in favor of one Dulia Behra and others. My lord, page 3, para 3, my lord.
Page 3, para 3, third.
Second sentence, my lord, in the year 1974.
In the year,
In the year 1974, the said land was leased out in favor of one Dulia Behra and others under the lease principle by lease case number 2989 of 1974. Para 4 says that in the year 1983, the lessee Susila Beva, if the land was leased out to Dulia, how did the leasehold rights flow to Susila Beva? That is not written. That is number 1. Number 2, my lords, is that annexure 4 has been mentioned as being the order of the Tahsildar for conversion. But annexure 4, my lords, will find as something else, my lords. Annexure 4 is at page 25. This is an order of this honorable court, my lords, coordinate bench.
Annex.
all exchange.
My lord.
Ordinary. Type करला पड़े.
सेटा भूल है इसका.
कौन करिया?
Modify.
Modify करिए. Land council for the petitioner seeks some time to file an interim application for amendment put of this matter after the interim application is filed for amendment. Serving a copy and the land council for this state. Yes, next.
Item 12.
May it please the Lord, sir. Sir, the land of the petitioner was acquired under Section 4.1 through a compulsory acquisition proceeding, my lord, by the state. Lord, in the year 2002, my lord. Lord, sir, may kindly see page number 14 is annexure under annexure 1. The land of the petitioner was acquired, my lord.
In 2002.
My lord, in
Yes,
2002, my lord. After this, my lord, what has happened? They have not taken any steps for the our procedure, my lord, under section 11.
Section land acquire hela,
my lord, for industrial purpose, my lord.
Industrial.
My lord, for industrial purpose, there was a compulsory acquisition, my lord. After 2002, my lord, after this section 4.1 notification,
Yes.
they have not taken any steps for disbursement of the, my lord, compensation amount, which is an admitted fact, my lord. Now, my lord, what the petitioner did, the petitioner under annexure 3 have represented before land acquisition officer, which your lordship will find at page number 90.
This court in annexure 2.
My lord, that is under the same notification and under the same moja, my lord. One another person, my lord, approached this honorable court. This honorable court directed the land acquisition officer, my lord, to initiate the proceeding under the new act, under the 2013 act. As the section 11 proceeding has not been run till date, my lord, that person, my lord, in the writ petition before this honorable court, that writ petition was filed in the year 2016.
Okay.
And the order dated, my lord, 2024, the annexure 2 order has been passed. The operating portion, my lord, lordship will find at page number 18. In view of the above, since the land acquisition officer has prayed for leave of this court to proceed in accordance with the provision of right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013 for acquisition of the plots, let him do so as expeditiously as possible so as to pass necessary award and dispose the same in favor of the petitioner. The steps shall be taken by him within a period of 4 weeks so that the relief sought for by petitioner can be granted. My lord, this was the order passed. After this, my lord, I have approached the land acquisition officer.
This was passed in your case.
No, my lord, in other case, but for the same purpose, my lord, under the same notification and in the similar village.
Presentation under Annexure 3.
My lord, I have said that, my lord, as per section 24 of the new act, it says if section 11 award has not been passed after the 4-1 notification under the old act, then the new act will apply, not the old act. And I have, my lord, I have quoted that in my writ petition, my lord, at page 5. Page 5, lords of may kindly see my writ petition.
Page 5.
My lord, 5, I have in the second paragraph, I have stated that, however, in view of the provision under the Act 2013, it is open to the authorities to initiate a proceeding for acquisition of the land under the provision of the Act 2013, unless the opposite party so choose to initiate appropriate proceeding for acquisition of the land under the Act 2013, the petitioner will suffer irreparable loss. My lord, I have quoted the section 24, which says land acquisition process under the Act number 1 of 1894 shall be deemed to have lapsed in certain cases. Subclause 1 says, notwithstanding anything contained in this act, in any case of the land acquisition proceeding initiated under the Land Acquisition Act 1894, my lord, may see the next page, where no award under section 11 of the said Land Acquisition Act has been made, then all provision of this act relating to the determination of the compensation shall apply. My lord, I am, my lord, stressing upon this. My lord.
Yes, then what after?
My lord, they have not passed any order under section 11. My lord, now in reply to my representation under Annexure 3, they have replied, my lord, under Annexure 4, which is impugned herein. Now, my lord, lords, you may kindly see page number 27 is the impugned order. My lord, they have said, in inviting a reference to the subject cited above, I am to intimate you that Khata number so and so area has been acquired under the project under LA Act 1894, wide 4-1 notification number so and so in 27/3/2002. But award has not been passed in respect of this plot due to sub judice in court. So it is to submit that now the compensation for the above plot in the new Act 2013 would not be paid as the land acquisition process has already been completed under LA Act 1894 and possession also has been handed over on dated 23/2/2004. Therefore, you are requested to come to this office along with relevant documents pertaining to above plot for receipt for compensation. Therefore, as per LA Act 1894. My lord, first of all, they have said that there is a case pending, my lord. But there is no such case pending, my lord. I want to take your lordship back to the Annexure 2, my lord, where the order has been passed by this honorable court. What the land acquisition officer did there, I want to highlight that, my lord. At page 17, my lord, and paragraph number 7, the affidavit so filed by the land acquisition officer Ganjam so and so, being a false one, the same has got wide ramification because the responsible officer of the government has filed this false affidavit before this court. Therefore, he is liable to be prosecuted criminally under section 340 of the CRPC. Accordingly, this court directs that for filing of false affidavit before this court, prosecution be launched against him before the court below and action should be taken for filing of such false affidavit before this court in accordance with law. My lord, why I am saying this, my lord? Because before this also in that particular, my lord, Moja and that particular notification, the land acquisition officer have filed false affidavit before this court. Now in my case, they are saying that because the case is pending, sub judice, so that we are not giving you the compensation, which is a false one.
Stated that no case is pending.
Yes, my lord. I have not stated in this because they are saying that you come to us and take the award under the old act. Now, no section 11 has been passed, my lord. No land acquisition proceeding.
That means in the garb of
My lord.
pendency of a case
Yes, my lord.
showing a legal impediment before
my lord.
them, they
My
could
lord.
not disperse the
Yes, my lord.
So the whole crux of the issue is that if there was any case pending,
My lord.
that prevented that.
In Annexure 3.
Yes.
My lord, may kindly see Annexure 3, my representation before the land acquisition officer. I have said that.
This petition are telling you,
Yeah.
they're asking you that
My
since
lord.
that is the crux of the matter,
My
you
lord.
should have taken the averment that no case is pending.
Because, my
Therefore,
lord,
the
You could have denied.
my lord, they have saying since long that
No,
there is a case
that is
pending.
not pertaining to you.
My lord.
You
My lord.
have a separate case.
My lord.
You could have denied it.
Because, my lord, they have not stated which case, what case. I
That
have
is how you
stated.
should have denied.
My lord. My
No
lord.
case is pending. That's all.
I have denied, my lord, but
Where is
in
that?
the representation, Annexure 3, page number 19.
No, Annexure 3 is a representation.
Annexure 3, my lord, what I have stated there, but award was not passed by the land
No,
acquisition
past
officer.
is not the thing.
My lord, that there was a civil case is pending for the above land without
No,
mentioning the case
now
number
that
and
you are
year.
challenging Annexure 4,
Annexure
you
4.
should have denied it.
My lord, because Annexure 4, they are saying that you take the compensation.
Obviously,
But
because
before
there was
that,
a
they,
legal impediment for
my
which the
lord,
disbursement could not be made.
my lord,
you have in your representation, you are right. You have stated that no case is
yes, my lord,
pending.
my lord.
But in this repetition, you should have taken that averment.
My lord. That is true, my lord, as
All right, you take instruction in this matter. This writ petition has been filed by the petitioner Bhairav Charan Sahu, challenging the communication made by the land acquisition officer Ganjam Chhatrapur, opposite party number
my lord, opposite party number 3.
3, dated 4/10/2024, wherein it has been held that the compensation for the land appertaining to Khata number 73, plot number 1347/1717, area Ekersun 040 decimal, acquired for the project under LA Act 1894 by 41 notification number 17018 dated 27/3/2002. Compensation cannot be paid under RFCT LA R&R Act 2013, as the land acquisition process has already been completed under LA Act 1894 and possession has been handed over on 23/2/2004, and therefore the petitioner was requested to by the opposite party number 2 to come to the office with relevant documents pertaining to the plot in question for receipt of the compensation as per the previous act, that is LA Act 1894. It is the contention of the land council for the petitioner that even though the land was acquired on 27/3/2002, no award was passed, and in view of section 24 of 2013 Act, which stipulates that where no award was passed under section 11 of the Land Acquisition Act 1894, all the provisions of 2013 Act relating to the determination of compensation shall apply. And it is an admitted fact that no award has been passed. He further argued that in the impugned communication, it is mentioned that case is pending with Raja.
My lord, there, my lord.
The award was not passed in respect of the said plot as due to sub judice, case was sub judice in court. However, in the representation dated 22/8/2024 by Annexure 3, this petitioner has specifically stated that no case is pending relating to that land. Therefore, the impugned communication dated so by Annexure 4 cannot be sustained in the eye of law. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Land counsel for the state accepts notice on behalf of opposite parties number. समझ पाई ना 1 2 3
1 2 3
1 2 3 ଆଉ ଏମା 8 को ପାଇଁ କି ଅଛନ୍ତି ପ୍ୟାନେଲ କାଉନସିଲ ନା ନାଇଁ ଯିବ ନୋଟିସ ଯିବ
My lord,
ଆପଣ
my lord, I'll
ଆଚ୍ଛା
give it to my lord,
hence
senior.
Mr. T.K. Mahanti and senior advocate appears for the opposite party number would usually let a copy of the writ petition be handed over to the land council by tomorrow for those who they
Thank you.
will
My lord, by tomorrow.
by tomorrow matter to be listed 4 weeks after the counter affidavit if any filed in the meantime.
Lord, obliged.
Mr. Naik, you can also see what about this title suit number 6 of 1993.
My lord. My lord.
That is land concerning the Haldia Padar
My lord.
construction. Autonomous.
Obliged.
Item number 13.
Yes, Mr. Das.
Here, the land of the petitioner has been utilized by the electricity company without initiating the process of land acquisition as well as not paying any compensation, my lord. My lord, earlier I have approached this honorable court against such irregularities, my lord. This honorable court, while disposing the writ application, granted liberty to approach the state government. Accordingly, I have filed a misappeal before the collector, Bolangir, my lord. The lordship turned to Annexure 1, page 18, my lord.
Annexure 1 is the order passed.
My lord.
Yes.
Page 18, my lord. Start after hearing the advocate for the petitioner and the executive engineer TPDOC Bolangir, it is observed that the schedule of land belongs to late Dhanurjay Gonda, who is the father of Dhruvacharan Gonda Kumbar, petitioner in this case. Necessary permission and procedure should have been followed before the construction of electrical substation in the said land. Hence, this case is disposed of with a direction to the TPWDL to make necessary correspondence with the concerned department for direct purchase of the land from the landowner on payment of compensation as per provision laid down in the 2013 Act within a period of 2 months. Intimate Advocate General. Then this order was challenged by TPWD and the order was passed page 26, madam. In course of hearing, land counsel for the petitioner states that highlighting that given the petitioner have made representation to the opposite party number 4 by Annexure 9, and same may be directed to be considered within a stipulated time, to which the land counsel for the state has no objection. As agreed by the land counsel for the parties, and after going through the records, this court, without expressing any opinion on merit of the case, disposes the writ petition directing the opposite party number 4 to consider the representation filed by the petitioner by Annexure 9 and pass appropriate order in accordance with law within a period of 4 weeks from the date of production of certified copy of this order. Well, against non-implementation of the collector, I have also filed a writ application before this honorable court. The order is page 22, my lord. Page 23, the operative person, my lord. As agreed by the land counsel for the party, and after going through the record, this court, without expressing any merit of the case, disposes the writ petition directing the opposite party number 4 to consider the representation filed by petitioner by Annexure 2 and pass appropriate order in accordance with law within a period of 4 weeks. Then both the order were taken up and Annexure 5, your lordship may turn to page
28, madam. May I please?
Yes.
Second paragraph. It is relevant to state that the electricity distribution license TPWDL had filed a writ petition before the Honorable High Court of Orissa by WPC number such and such, calling in question the order dated 13/1/2022 of the Land Collector and District Magistrate Balangir under reference. TPWD has also apprised the Department of Energy, Government of Odisha, by letter number such and such dated 23/9/2022 on the said order of Land Collector and District Magistrate Balangir. Meanwhile, the Honorable High Court has been pleased to dispose of the said petition filed by TPWDL in WPC number such and such, but order dated 22/11/2022 with a direction to the Department of Energy, Government of Odisha to take a decision on the representation filed by TPWDL by letter number such and such dated 23/9/2022 within a period of 4 weeks from the date of communication of the said order. Consequent upon disposal of the said petition, TPWDL apprised the Energy Department by letter number such and such dated 29/11/2022 and requested to take a decision on the matter. In view of the aforesaid factual development, you are requested to wait for the final decision of the Energy Department, Government of Odisha. Upon receipt of any decision by the Energy Department, Government of Odisha, TPWDL will take necessary and appropriate action with respect to purchase of land and payment of correspondence thereof. It is made clear that since the matter has been placed before the Energy Department, Government of Odisha, and the latter shall take a decision as per the direction of the Honorable Court, we are not placing any view on the merit of the matter. Then your Lordship may turn to the order of the Energy Department, next page 30, madam, Annexure 6.
Operative part question.
Paragraph 6, madam. Page 31. Having regard to the facts and circumstances indicated above, the undersigned finds no illegality or impropriety in the order passed by the Collector Balangir. To reiterate, although the electrical substation installed over the land in question is an existing property of the Government of Odisha, TPWDL and used by TPWDL by virtue of the vesting order, there has not been acquisition of the land from the recorded owner as per the governing law. Hence, CEO TPWD is directed to take steps to purchase, acquire the land in the name of Department of Energy, Government of Odisha from the rightful or the recorded owner of the land with necessary approval from all concerned on payment of compensation as per provision laid down in the concern on payment of compensation as per provision laid down in the Right to Fair Compensation Act 2013. The payment towards such compensation shall be governed under the respective vesting order of the Commissioner OERC. Accordingly, the representation. Thereafter, the matter was placed before the Advisory Committee, my lord, District Advisory Committee, Annexure 7, page 34, my lord, for determination of the market value of the land.
What happened?
My lord, your lordship, may I place, my lord, page 34.
34.
Determination hela na nahi?
Yes, determination. Next page 35, determine hela.
Okay,
then compensation, page 33. Your lordship, turn to page 33.
Yes.
This was the estimated for direct purchase of private land of village Kaprakhol for the purpose of 33 11 kV grid station. This amount was determined, my lord. And thereafter, my lord, Annexure 8 order was passed, page 36, my lord. The land acquisition officer issued a letter to the TPWD, second para. Further, you are requested to deposit 2% of the contingent amount worth such and such only in favor of the land acquisition officer, Collector Balangir, at the earliest to SC paid check. Receive the estimate. Now, the matter is like this, my lord. No steps have been taken by the TPWDL to purchase the land and to pay compensation.
So, who is appearing for?
Mr. Anindya Mishra was appearing, my lord. In the earlier occasion, because TPWDL filed the case through him, my lord.
So, have you offered a copy to him? He said no.
Sir.
He na kon kahle?
Anindya Kumar Mishra.
Annexure 8 is to the superintending engineer. Opposite part number 4 is the executive engineer. So I don't know if Maybe the superintending engineer needs to be made a party.
Hmm. This writ petition has been filed by the petitioner Rupacharana Kumbhar. With a prayer for a direction to the opposite party number 3 and 4 to release the compensation in terms of the order dated 13/1/2022 under Annexure 1, so on so like that. With a further direction to the opposite party number 1 and to pay compensation to the petitioner as per order number 1. The land counsel for the state submits that the Annexure 8 has been addressed by the Land Acquisition Officer Collectorate, Balangir, to the Superintending Engineer TPWODL, Electrical, Circle, Balangir, who has not been made a party. The Land Counsel for the petitioner submits that he will file appropriate application to make the superintending engineers want to as a party. However, he submits that this TP or WODL, Mr. Anindya Kumar Mishra used to represent TPWODL, and he will serve a copy on him during course of this week, right? Matter be listed in the week commencing upon an interim application they will file for the so that tomorrow matter be listed in the week commencing from 18th for example. It is the name of Mr. Anindya Kumar Mishra in the cause list. If an interim application is filed by so and so, the same may be placed on record and copy of the interim application be sought on the Land Council for the state who is appearing for opposite parties number 1 and 2. So also on Mr. Mishra. Yes.
Item number 14.
In this matter, but I have only understood the reasons for the cancellation of the allotment already made. No doubt the allotment was made, the agreement has been signed, all these things. But later on it was found that high tension tower line is over that, and a very big drain is going on, is also under the that. So that
you are appearing for whom, Mr. Mahanti?
For the
IDCO.
Yes.
So have you filed your counter affidavit or you?
Yes, yes. For which time let's kindly give.
All right.
Sometime December may be listed.
Okay. Mr. Pradip Mahanti, Land Senior Advocate, 6-4 weeks time to file counter affidavit with this matter in the week commencing from 9th
December.
December 9th. 9th of December 9th.
Lordship may not keep it that week. I have a marriage in
Kebe?
9th week.
16th of December 2024. Counter affidavit, if any, be filed in the meantime, serving a copy on the Land Council for the petitioner. If he so likes, can file the resident affidavit. Yeah.
Interim, my lord, I am protected by status.
What is the interim order you want?
Status, they have since cancelled my allotment. I am in possession. Let status.
All right, the status quo as on date shall be maintained till next date. IA numbers 1. Yes.
Privilege.
Item number 15.
Item number 15, my lords, may please, your lordship.
Yes.
My lords, here my limited grievance is for dispersal of the structure compensation, which was granted in favor of my mother And my lords, this is pursuant to the direction of the Honorable Apex Court. This is regarding the MCL case, my lords, Claims Commission and MCL matter. And my lords, here what has happened after the death of my mother, I had filed a claims case, and specific prayer was to disperse that structure. It's not that. So my lords, may I pray I'll make a fresh representation to the collector, because collector has actually issued notice to my late mother.
Petitioner submits that the petitioner has filed this writ petition. Petitioner Sushil Naik has filed this writ petition with prayer for disbursement of the structured compensation in favor of the petitioner and other legal heirs. As the land has been acquired, which was in favor of late Nirmala Naik with respect to Khata number 129, plot number 1531. It is submitted that through a representation dated 20/12/25 has been filed before the Land Claims Commission, but since the Land Claims Commission is not functioning now, and the matter is sub judice before the Honorable Supreme Court, let the petitioner be permitted to file a representation before the opposite party
Number 4. My lords, number 4, because the ADM. Yes, my lords.
Opposite party number 4, Additional District Magistrate R. Sundargarh, seeking the relief sought for, and seeking the relief, and the same may be directed to be considered in accordance with law within a stipulated period. The Land Counsel for the state has no objection to such prayer. In view of the submission made, the writ petition is disposed of that in the event the petitioner makes a representation before the opposite party number 4 within a period of 4 weeks.
4 weeks.
Same shall be considered within a period of 3 months. Necessary order to communicate to so and so within 15 days of the date of taking the decision. It is made clear that we have not expressed any opinion on the representation, which is likely to be filed by this one. Yes.
Grateful.
Item 16.
My lord, here only prayer is before your lordship is to direct the ADM, the opposite part number 1, for early disposal of the revision case. My lord, fact remains, it is initiated under 7A3 of the OGLS Act.
Who depending actually?
ADM Cutoff.
Competent authority.
And there twice it has been heard. Written note of submission is filed, but they are being transferred. Thereafter another is coming, it is not disposed of.
Upon basic argument, this prayer has been made for a direction to dispose of OGL division case number 1, which is sub judice before the Land and Additional District Magistrate, na?
Additional
District Magistrate within a stipulated period. Land Counsel for the state has no objections. Considering the submission by Land Counsel for the petitioner and the opposite party, the state, the opposite party number 1 shall do well to dispose of this such case within a period of 3 months from the date of production of the certified copy of the order. Yes, next.
Item 17. May I please your lordship? My only limited grievance is the petitioner is challenging the inaction by the opposite party, delaying the disposal of the representation.
Position notice.
Notice is upon 13 for notice.
13 for
You have
notice.
to go to the appropriate forum. 13 for notice challenge, appropriate forum. Disposal. Just like
Item 18.
May I please my lord, the petitioner is a lady who had taken loan for construction of her house, and she had taken loan in 3 occasions. One is 19,000, thereafter 11,000, then 16,000. Altogether 46 lakhs. Altogether 46 lakhs she has taken loan. and she has already paid 51 lakhs some odd money. But unfortunately, her husband expired, who was managing the things. And in the COVID, she expired. I have annexed the document in annexure 1 of my petition, my lord. The problem is that now the lady, after the COVID, there is some discrepancy in payment of the dues of the petitioner in different occasions, but in the COVID period,
What do you want now?
because I want to settlement of the account, my lord.
How? What
Because-
we will do?
Because
What we you
because
want
they are
us-
not giving me opportunity to sit with them.
No,
to-
it's a Reliance Home Finance Limited.
Yes.
It's not a private entity. How can we issue it to him?
No, it is not a private. It is
Then-
a Reserve Bank. After getting
No.
Reserve Bank,
Say Reliance Home Finance Limited. Can it come within the definition of the state?
no,
So that yes, that is why then
because they have taken action under the Surface Act
we do not know.
that
You
I
are-
have
you
challenged.
say-
That I have challenged in the.
Where you challenge?
That is, I have challenged in annexure 3 year lordship may
Then you
kindly
challenge
see.
it to the appropriate forum.
No, prayer nahi. That is not in my prayer.
Then-
Was there only in my
Notice has
petition
been
I have
already
stated.
issued. I think for notice has already been issued.
Yes, my lord.
Then it-
No, that court.
My lord,
That court.
I appear for the opposite party.
Yeah.
The petitioner was before this honorable court earlier also in a
On that
petition.
I have stated. I have stated
And
in my
she
petition.
was directed to pay certain amount within a stipulated period, failing which the finance company can take action in accordance with law.
Yeah.
That also not done. And probably,
Well,
my lord, she
after the
challenging the
director-
order of the district magistrate, my lord, under section 14.
Oh. କାହିଁ କିଛି ତ ଲେଖି ନାହାନ୍ତି ଆପଣ ସେ 14 ଏଗୁଡା ସବୁ ଷ୍ଟେପ ନିଆହେଲାଣି କିଛି ତ ନାହିଁ what is that order?
That order is annexure that the previous order of the honorable court, my lord. No, that is the order of the lower court. I have annexed annexure 3, my lord.
Annexure 3 is
Annexure 3.
CJM.
CJM,
Yes, CJM court.
So
They have
CJM has
taken-
passed the order in 14.
Yes,
Yes,
that
yes,
is
my-
what is the challenge, my lord. I am
My
saying
lord,
my
I have
prayer.
challenged that, but my prayer is only simple prayer.
That is an order under section 14.
14 of
Yes.
the act,
What
and
is
it
the
was
challenge
passed
to
in
that?
January 24, ma'am.
My lord.
Sorry.
So what happened thereafter?
Thereafter, I have paid 1,60,000 rupees to them.
No,
But,
ଏଇ ଯୋଉ ଲେଖା ହେଇଛି operative part ରେ that
the subordinate officer
so and so
refrained
for
from or to delay the recovery of the possession, my lord. That one official was been appointed, is a fresh advocate, and he was appointed
and IC local
to
place
take
to secure
as a
creditors
secure
for their
creditor.
information.
so this is not the forum to challenge that order under.
My lord, I have challenged in my averments, but I have my prayer is very limited because let them sit with us.
There is alternative remedy available. So go on this.
Well, that's right, my lord.
challenge the order
That
passed under
alternative remedy, because after taking action,
14 of this one. So
yes, after
hence,
taking action, my lord,
dispose of the 14 order against the alternative remedy. They are not inclined to entertain this situation.
my lord, your lordship
Guidance may
may
be
kindly allow me to sit with them
Yes.
today. My lord,
It
to
is
sit
up
with
to the
them
petitioner
to settle the account.
approach the opposite party number for settlement, and it is up to the opposite party number to the needful in accordance with law. We are not expressing in uncounted, but the petitioner submitted. The petitioner may be given external for and be permitted to approve this one. So for it is up to the petitioner to approve and
Let them-
yes.
Let them be directed to.
No question of direction. Once it is not maintainable, so we are just adding that line. That's all. Yes, next.
Item
Your name
19.
has been reflected here.
No, not my lord. I am given the name. Obliged.
19 lords ordered the Tahsildar Cuttack to conduct a fresh inquiry, my lords. That he has not been able to do. I pray, my lords, may call this matter in the second week of December. Because of Bali Jatra, he may be otherwise busy.
Okay.
My lord.
And counsel for the state submits that the matter may be taken up in the second week of December 2024. Mr. Nirud Kumar Saul and counsel for the petitioner is present.
I am for
I am for the petition.
he is
No, no,
the
there are
petitioner
two-
in the review
there are
petition.
contempt petition. One is the
Nah.
contempt
Your
petition,
lordship
another.
passed the order.
One
in the review
contempt petition, and they have filed the review petition.
Okay, so and so, like Neeraj Kumar Sahu in contempt.
Yes,
for so and so, and Mr. Pradeep Kumar Mahathir and senior advocate for in the review petition number so and so. Matter to be listed in the week commencing from 9th December 2024. That's
Lordship direct also to comply with this order. And to submit the report.
to land counsel for this one so to apply this quote about the compliance of the order. Right? Yes, next.
Item number 20.
No one is there. Next.
Item number 21.
Maybe. The petitioner has been convicted for life.
We are just coming with the mark.
Yes.
number 21. Yes.
21.
Item number 21.
Yes. The petitioner has been convicted for life for the offence under section 302, along with a fine of 5,000 in default, rigorous imprisonment for another 1 year.
So, what is your period of detention? Since when you were in custody?
6/9/2015.
Huh?
6/9/2015.
5 no?
6/9.
Oh, 6 no?
6/9.
Yes, ma'am.
6/9/2015.
Yes, my lord. More
302.
yes, my lord.
Okay.
More
So,
than 9 years in custody.
earlier your bail application was never rejected.
No, ma'am.
Okay. Now, what is the prosecution case? Come to the judgment, page number, paragraph 2. Let us see. You face trial along with 3 others.
Along with another.
Judgment are 4 जनों नाम अच्छी पर.
No, my lord.
No.
2 persons.
Ram Munda and Samari alias Sambari Munda.
Item 21.
Yes. So what happened to that?
2 has been acquitted by court.
2 has been acquitted. Okay. So come to the paragraph number 2. Let us see that.
On 5/9/2015 at about 10 a.m., the informant appeared before IIC Bambari PS and lodged a written report alleging that on 4/3/2015 at 9 p.m., her mother, Suru Munda, went to the house of one Maheswar Munda of the village to consume handia. But due to prior enmity, the accused Ramamunda dragged her mother from the house of Maheswar Munda to his courtyard, thereby assaulting her to attend a meeting. Further, the accused Ramunda assaulted her mother by means of a spade, gointia, to her head, causing serious bleeding injury, and her mother fell down on the ground. Despite her request, he did not listen, and his wife was instigating him to assault. As a result of which,
is there any eyewitness to the occurrence?
eyewitness PW 1 and 2.
And who is the doctor?
Doctor
PM doctor.
PM doctor is PW 14 minor.
So please come to one of the eyewitness. Let us see what he has stated. PW 1 person. Yes. Please, paragraph number 2.
Paragraph 6.
2.
Yes, my lord.
PW 1, paragraph 2. Eyewitness.
Yes, my lord. The informant PW 1 has candidly declared on oath.
कौन पढ़ुଛନ୍ତି?
No deposition.
Deposition copy ନାହିଁ.
No.
କେମିତି ବେଲ୍ ଆପଣ କେମିତି ଇଏ କରୁଛନ୍ତି?
ଏଇଠି ଅଛି।
Please come to here. 302 ରେ ଆପଣ ବେଲ୍ ମୁଭ୍ କରୁଛନ୍ତି, ଅପିଲ ଫାଇଲ କରିଛନ୍ତି, ଆପଣଙ୍କ ପାଖରେ deposition copy ନାହିଁ. It is unheard of, really. How did you prepare the appeal memo? Please place that.
On 4/9/2015 evening hour, my mother deceased had been to the house of one Maheswar Munda of our village to take handia. The accused Ramamunda brought my mother deceased by dragging and assaulting near to his house to attend a meeting, suspecting her as witchcraft. The accused Ramo was assaulting my mother using a salt stick, and I requested him not to assault. Thereafter, the accused Ramo, by means of a gantia, that is a wooden handle fixed with the iron having 2 sides a sharp edge, to the back side head of my mother and also front side. With profuse bleeding, she fell on the ground. The wife of the accused, namely Samra, instigated the accused Ramo to assault further.
Okay, now you come to the evidence of the doctor. PW 14 you said. चौदह नंबर साकी बाहर कले
Yes, ma'am.
एक्सटर्नल इंजरी पड़े आसुन
External. lacerated injury seen on the right temporal region of size 1 into 1.5 inches with a fracture, underlying skull bone, and communicating with the brain matter. Lacerated injury seen on the left temporal region of the size 3.5 inch into 3.5 inch with a fracture of underlying skull bones and communicating with the brain matter. Third, lacerated injury seen on the left cheek in preocular region of the size 1 into 1.5 inches.
Okay, cause of death is due to
Brain
injury, that is vital organ homicidal death. So ଆପଣ ମୁଣ୍ଡରେ ମାରିଲେ ଗୋଟେ ଫାଷ୍ଟ ଗୋଟେ ବାଡିରେ ମାରିଲେ ତାପରେ ଗଇଁତିରେ ମାରିଲେ ଶାଳ ଷ୍ଟିକ୍ ଗୋଟେ ମାରିଲେ ଗୋଟେ ଗଇଁତିରେ ମାରିଲେ 6/9/2015 Heard the learned counsel for the petition, learned counsel for the state, the learned counsel for the petitioner submits that the petition is in judicial custody since 6/9/2015, and paperwork has not been prepared, and therefore there is no chance of early hearing. Balance of convenience is in favor of the petitioner. Therefore, the bail application may be favorably considered. And counsel for the state oppose the prayer for bail. Place the evidence of 2 eyewitnesses, that is PW1 and 2. Also, the doctor bracket PW14 who conducted post-mortem examination and noticed external injuries on the temporal region and opined the cause of death due to injury to the vital organ, the brain, and it was a homicidal death. Considering the submission made by the land counsel for the respective parties in view of the available materials on record, while not intending to release the petitioner on bail on merit, but taking into account the period of detention of the petitioner in judicial custody and the ratio laid down in the case of Letty versus State. So Letty was a paragraph that's quote for the 3 months bail granted, and report is to be called for regarding his conduct right on interim bail. Yes. Okay. And another application is there for stay realization that is to be state. Yes.
Item 22.
Present appointment convicted under section 302 IPC for life and under section 25 and 27 arms act, my lord.
He has been called for a criminal accident.
No antecedent. That report has not I press on.
On 110.
Custody certificate was called that has
Custody
not received.
certificate is
No,
there.
custody certificate earlier.
Criminal accidents.
No, the last order which indicate that the state council is to obtain instruction regarding criminal act. Since you use each arms mainly
eyewitness
for eyewitnesses are there. Arms act conviction.
I pray for some time because now.
Okay. Have you sought for instruction?
Report does not disclose me.
Order pass ହେଇଗଲା ତାପରେ ପଳେଇଲେ ଅଫିସ ଲେଖା ଲେଖି ହେଲାନି 1/10/2024 ମାସେ ହେଇଗଲାଣି.
Pray 1 week after.
All right. Land counsel for the state seeks some further time to obtain instruction regarding criminal antecedents, if any, against the petitioner as per the order dated 1/10/2024. This matter will be commenced from 18th November 2024. Yes.
Okay.
Item 23.
23 Millard, surrender certificate filed on 5/11. He has surrendered on 29/10 Millards. I have filed on 5/11/2024 Millard. I have a receipt also Millard. Right.
Surrender certificate ଦେଇଛନ୍ତି ଏଠି
on 5/11.
What is the surrender certificate man? କେବେ ଫାଇଲ କଲେ?
On 5/11 Millard.
ଆଚ୍ଛା ଓକେ ଏବେ ଫାଇଲ The land council, Mr. Satyabrat Mahanti, land council for the appellant submits that after availing the interim wait period, the petitioner appellant has already surrendered and he has filed the surrender certificate with the registry on 5th of November 2024. Let the same be placed on record. Yes, next.
Another, Your Lordship, and paragraph 10 has been pleased to direct the state to produce a report from the concerned IIC regarding
I
conduct.
will produce that report. No. The land council for the state seeks some more time, to produce the report from the concerned IIC regarding the conduct of the appellant while on interim there. Put up this matter on recommencing from. Have you filed any further application? No.
No, it's not.
25th, all right. 25th November 2020. Yes.
Next.
Item 24.
Yes, Mr. Mishra. कि 18 तारीख ना 25 तारीख के बेर अपन तो सीनियर किछ कहि ना सेमती तो 2 weeks after 25 तारीख 25/11 yes.
Item 26.
26, my lord, I am appearing for the petitioner in your lordship's board that is in the cause list. My name probably appears in the other reverse side. Though, in fact, I was not originally there. I filed my okaltnama appearing for the petitioner. Now, but I find that lot of applications have been filed.
You are
All
appearing for the petitioner.
my lord,
You
for the
name
petitioners.
acted as a counsel for the opposite party.
My lord,
So, is that
some
your
mistake,
mistake?
some mistake in the reprinting in the cost side.
ରମାକାନ୍ତ ମହାନ୍ତିଙ୍କର ନାଁ ଗରିଆ କଟା ହେଇଯିବ ଦେଖନ୍ତୁ ଆଉ ଆଜି କଣ ଚାହୁଁଛନ୍ତି ଆର୍ଗୁମେଣ୍ଟ ଆଉ ଗୋଟେ ଦିନ ନେବାକୁ ନା
ଫାଇଲ କରିଛୁ application. So we are the purchaser from the person who has been granted the lease.
Okay.
So we have not been
So many
imputed
persons are
parties.
intervened.
So have you received the copy of this?
Yes.
Have you filed your objection?
I have not filed any.
So, sir, I think with due respect, I don't know whether he's
Interested to file objection or not.
right. Question is
No, if he says then matter is all right. He can be given opportunity of hearing.
My lord, the
In our
opportunity that
presence,
your
it will be
lordship
hard.
can always extend.
No, no.
What I believe, my lord.
We will write now.
Yes, my lord. You will.
So we are allowing all the intervention.
Not all.
Sorry?
I will be filing an objection. IA 1342 at the bottom.
ଆପଣ କୋଉଟାରେ objection file କରିବେ କୁହନ୍ତୁ ଆଉ ବାକି ଗୋଟା allow କରିଦବା
1342 of 24.
13 sorry
Who is joining issue with the petitioner.
Just a minute.
140 is the last.
Towards the last, my lord.
ଏଗୁଡାକରେ କେବଳ objection file କରିବେ
1342 of 24, which I have received today also.
alright ବାକି ସବୁଗୁଡାକ allow କରିଦେବେ
ବାକି ସବୁଗୁଡାକ allow।
ଦେଖନ୍ତୁ ଟିକେ ସେଟା କଣ ପାଇଁ ଫାଇଲ କରିଛନ୍ତି ଆଚ୍ଛା ଆଇ ନମ୍ବର 23 okay. Mr. Sushant Kumar Das, Land Council, submits that he has filed power for the petitioners for them. But his name has been reflected in the cause list as the opposite party counsel, and the same may be corrected. Henceforth, the name of Mr. Sushant Kumar Das and his associates shall be reflected in the cause list as the counsel for the petitioners. The names of Mr. Ramakant Mahanti and his associates shall not be reflected in the cause list. Interim applications number so and so have been filed by Mr. S.P. Misra and senior advocate for intervention. The Land Council for the petitioner submits that he has no objection if the interim applications are allowed. In view of such submission, all the interim applications are allowed, numberlessly specifically, are allowed to be included as opposite parties. So far as IN number 134 of 2024 is concerned, Land Council for the petitioners seeks some time to file objection. Stop. Mr. Anso submits that he has filed an interim application by IN number 346 of 2023 for intervention, and the same may be placed on record. Put of this matter in the week commencing. केबे रखिबा कोंतु आपण objection टा फाइल करिवे तो 18 तारिख ना 25 तारिख जेबे कहबे रखो.
My learned friend is probably the same purchaser. So that also your lordship can allow.
नहीं सेटा आजी बोर्ड रे नहीं ना
order
बोर्ड रे आसीबो से ना
Right.
जे केबे आनीबा कोंतु आपण consensus रे नहीं आसीबो तो
Any day as your lordship.
Mr. Misra
On Monday.
Proper on 25th.
25th.
All right. List this on consensus of all the parties. List this matter on 25th of November 2024. Counter affidavit, objection if any to the interim application. You 1342 of 2024 be filed in the meantime. Serving copies on the Land Council for the
State intervention.
Yes, the intervention. बाकी तो सब बुरा का dispose of कर दो, है I yes.
Obligement.
Item 28.
27 for us. Which is correction to it. 27 is correct. Aguru he petitioner inadvertently typed the recordation. What the first one? Yes.
May I please, your lordship issue notice to the opposite I have filed a registered post instead of speed post. That may be accepted.
The repudiates file or issuance of notice by registered post be accepted. The office to proceed. Yes, next.
Oblige.
Fixing a date. Next.
Item 29.
29 also similar instead of speed post ballot.
Oblige.
Item 30. Item 31.
Your lordship to take up the read petition because also some documents from the read petition. Then I'll take a lordship to the read petition.
He is appearing here for the.
Other side. My lord.
Read petition means 15499 of
Yes, sir.
yes, my lord. Just we want to see that order which is impugned in this.
Yes, my lord. Then let's kindly see. Read up. Annexure 1. Annexure 1. My lord. Impugned judgment.
5517.
Yes. Page 30, it starts at page 38.
37. Upon annex to annex 1.
Ah, it's 37. Right.
37.
My lord, may I permit you to place it, my lord?
Yes.
The petitioner.
Just first paragraph.
Petitioner having stood fast in BB Science and AH course conducted in the year 1989 by Orissa University OUT and completed her MB Science in first division in the year 1992 in the subject veterinary bacteriology, virology by following due process of selection was initially appointed as research assistant under OUT in the scale of pay of 1640 to 2900 against the post of junior scientist at Mahisapat White Office, order dated 9/7/93. While she was so continuing, she qualified in the National Eligibility Test 1994. On 24/7/93, in partial modification office order dated 9/7/93, the petitioner who was posted as research assistant against the post of junior scientist was reposted as such against the post of lecturer bacteriology ISS plan Orissa Veterinary College. On 2/6/95, the petitioner filed representation before the register OUT to be appointed as ad hoc lecturer since she acquired the minimum qualification had been holding the post. Pursuant to the query made by the registrar OUT, the Dean of Veterinary Science and Animal Husbandry OUT filed letter dated 5/10/95 by pointing out that the petitioner has been adjusted against the post of lecturer, requested for publication advertisement to fill up the vacant post as per the list appended to the said letter. As no steps are taken for recruitment against the vacant post of lecturer, the Dean of Veterinary Science and Animal Husbandry OUT issued reminder to the register OUT to take steps for recruitment, and while stating so, specifically pointed out that the petitioner who was appointed as research assistant has been registered against the post of lecturer. The petitioner, referring to her earlier representation dated 3/6/95, again filed a representation on 21/7/96 to consider her case for appointment as lecturer. In the said representation, she stated that though she had already rendered 3 years of service as lecturer and was contributing as such, her case for appointment lecturer had not been considered, nor the post had been advertised. Even though for other disciplines, advertisement had been made by the authority, and research assistants working in other faculties had already been appointed as lecturer in the concerned department. By letter dated 5/8/96, the Dean of the Veterinary Science and Animal Husbandry OUT, while forwarding the representation of the petitioner to the registrar OUT, specifically indicated that there are 2 vacancies in the rank of assistant professor, one post plan, another non-plan in the Department of Bacteriology, and that action be taken to fill up the post so that petitioner could be adjusted. Petitioner again made a representation on 28/7/99 to consider her case for regularization post assistant professor, since persons below her and the select list had.
Mr. Please come to page number 4 means 41.
Yes.
The last 4 lines.
Yes, my lord. Hence, the application had been filed seeking for direction to opposite parties to treat the petitioner as lecturer assistant professor with effect from 31/7/93 and grant scale of pay of consequential service benefits and financial benefits as due and admissible to the post from that day. My lord, then your lordship kindly.
What is the final outcome of this
My lord,
petition?
final outcome, your lordship kindly see the petition has been dismissed. Your lordship, the para 7, my lord.
Has been given.
Para 7, your lordship kindly.
Reason has been given in para 7.
Para 7.
Please count.
The page 45.
Yes.
The relief claimed in this petition rests on the fact that petitioner, having been appointed research assistant, training assistant under the different schemes of the OUT in the scale of pay of 1640 to 2900 with usual allowance, and having been allowed to continue against vacant post of lecturer, is entitled to get the benefits of teaching experience and continuing in service against the post of assistant professor of bacteriology and virology in the veterinary college. There is no dispute that there are two sources of recruitment, namely recruitment to the post of research assistant training assistant, which is a class 3 post, and recruitment to the post of assistant professor, which is a class 2 post. Admittedly, the petitioner had been selected for the post of research assistant training assistant, person to which she joined on 31/7/93 against the class 3 post, and officially she was posted as junior scientist Mahisapat on her own request. This she was adjusted against the post of lecturer in veterinary college OUT, where she had been discharging her duty. That ipso facto may not entitled her to get the benefit of teaching experience as well as the continuity of service as lecturer or assistant professor from the date of joining as the research assistant training as to with from 31/7/93. The bone of contention of the Lord Counsel for the petitioner is that, as per the provisions contained in Statute 49, as she had been discharging her duties on 31/7/93 as lecturer, she would be entitled to senior scale of pay with effect from 1/8/2001. Statute 49 of the Statute 96 reads as follows. Whenever a permanent post in any grade or pay scale is available for substantive appointment in the claim of any university employee holding a tenure post of temporary post continuously for a period of exceeding 2 years in the grade and pay scale and possessing the qualifications required for the permanent post shall be considered first and substantive appointment in that permanent post. As a matter of fact, the petitioner was posted a research assistant, which is a class 3 post, which the state government scale up as so against the vacant post of lecturer. Lecture bacteriology in the College of Veterinary Science by the office order dated 24/7/93, in which she joined on 31/7/93. There was no sanctioned post of research assistant in the Department of Bacteriology and Virology and Veterinary Science and Animal Husbandry. Consequently, the petitioner posted against the vacant post of lecturer bacteriology with a view to provide her employment and assist teaching in the department. She was not selected and joined as lecturer in bacteriology with UG scale of so and so, and did not hold the class 2 cadre post duly sanctioned, duly selected by standing selection committee as provided under clause 3(1) of the 1 Roman 2 of the OUT statute 1966. Therefore, the petitioner, having not joined the same grade and the same scale as assistant professor, the question application of Statute 49 doesn't arise. While the petitioner was continuing as research assistant, she availed the study leave for prosecuting PhD degree on from 1/9/2000 to 29/2004, which was allowed as applicable to non-teaching employees of the university as per decision of the Board of Management resolution dated 21/1/2002. As the petitioner was discharging the duty of research assistant, she was drawing the scale of pay of admissible to the said post from 31/7/93 till 17/6/2005. The relief as sought for in the application having been considered by this court and earlier two writ petitions, number so and so, the same cannot be reopened in the present writ petition. The petitioner filed OJC 13411 of 19 with the following relief. The regularly the post of lecturer bacteriology in the veterinary college of opposite pet number 1 in the opposite pet number 3 from 37/93, the petitioner be given all emoluments attached to the post of lecturer from 30th July 93 and other benefits as permissible under law for the date of joining as lecturer. That the court disposed of the petition by order dated 29/1/2003, directing that as and when university considered the question of appointment and filling of the post of lecturer bacteriology, it would be also considered the case of the petitioner keeping in the academic qualification, NET certificate, and the experience in the in accordance with statute. Consequently, the advertisement was issued for in the year 2005. The petitioner appeared before the standing selection committee and recommended and on recommendation she was appointed assistant professor bacteriology. She again filed WPC number so and so, seeking for benefit as were sought for in OGC number so and so. When the grievance of the petitioner was already considered and decided earlier, pursuant to the direction of this court, she has been appointed and joined as assistant professor. She has once again approached this court claiming continuity of service from 31/7/93 till 17/6/2005. After her grievance was rejected by the authority, though exactly the language had not been couched in the present repetition, effectively the relief sought for is the same and similar that of earlier to the publication. Purilal Mahto versus WPC no so and so. This was upon so and so date. A similar question had come up for consideration before this court. In that case, the petitioner was functioning as lineman A and allowed to continue for some period to discharge the duty of junior engineer. And joining of the junior engineer, he again functioned as lineman. Lineman A claimed that he should be allowed to continue as junior engineer. This court declined to grant such relief to the petitioner. Applying the said analogy, the present case, since the petitioner admittedly joined as joined a class 3 post as research assistant by following due procedure of selection, merely because she was discharging the duties of the vacant post of lecturer with admittedly class 2 post, she cannot get the benefit of continuity of service against teaching post from the date of her joining as a research assistant on 31/7/93 till 17/6/2005, on which date she was regularized as assistant professor by forming due process of selection as class 2 post of OET. In view of the above, circumstances, the petition and nobody dismissed. Well, let's kindly look at the writ petition, then I'll take your lordship to the why these reasonings are wrong. Well, kindly page 25 of the writ petition.
That is the office order.
25 of the writ petition, annexure 2.
Office order লেখা আছে।
Office order.
One আছে item number serial.
Item 1 আছে জন্য research assistant against the post of junior scientist. Junior scientist is a class 2 post. Junior scientist admittedly junior scientist is a class 2 post. Well, let me kindly turn to this the first upon letter because she was selected in that year. Following. Then ballot annexure 3, page 27. In partial modification, the office order dated 9/7/93. Let's kindly see this order dated 9/7/93. This was modified. Partial modification office order dated so dated 9/7/93. Dr. Mrs. Rajesh Mishra was posted research assistant against the post of junior scientist. So is reposted as such against the post of lecturer bacteriology ISS plan BC. So his initial appointment as lecturer is from the beginning, my lord. Then my lord may kindly see.
Beginning में 24
sorry, my lord.
24/7/93.
Yes, this was the 9/7/93. She was first appointed as research assistant. That was modified, and she was then appointed as lecturer. Appointed as a lecturer. Page 27. Was appointed as a lecturer. Then, my lord, will kindly see. She represented and all that. Represented and all that. Then, my lord, may kindly see. Page 11, page annexure 11, page 39. Page 39, my lord. Then I'll take a lordship to the end.
Yes.
This is the dean's recommendation. Because admittedly there was a vacant post of lecturer. Inviting reference to the subject cited above, I am forwarding here with the appendation of Dr. Mrs. R. Mishra RA against post of lecturer assistant professor essay plan bacteriology for information and necessary action. The professor and the department has forwarded and recommended her case as she has been academically sound and qualified for net examination. She has engaged in teaching and research work in the department as a bacteriologist since the date of her joining. As such, it is recommended that her case please be considered for appointment to the post of assistant professor bacteriology, and who has been adjusted by your office order dated 24/7/93. My lord, then kindly Lord, kindly listen to the now earlier writ petition which has been basing on which Honorable Single Judge has virtually dismissed the Lordship. Kindly look at the earlier judgment, my lord. Panel. The counter they have filed. And the counter OUT has filed that judgment. And the counter, Lordship. Counter, if Lordship will look at the counter, page 31 of the counter. Counter in the writ appeal itself. Because basing on this, Honorable Single Judge has dismissed the
Which is the page number? What is the
page 31 of the counter.
So paginated hochi apna no na digi.
Oh, no. Oh, I'm so sorry.
Pen drive re nahi gale subidha honta apna.
I'm so sorry.
पूरा entire brief टा paginated ही
ताले मु पेजिनेट कर दूचे ताले आसु
नहीं ही तो paginated already ही
हे हे तो मु पेजिनेट नहीं कि संसार कर दूचे
pen drive रे नहीं जाऊँ ना थी
हाँ पेन ड्राइव टा नहीं भी नहीं कि कर दे नहीं कर दे
that would be better कारण अपन relate कलार को हमें ये
मतलब पेन ड्राइव नु नहीं होची ताले आसु ता मंडे आसु तो कर
next
दे
week Monday ने
मंडे
Tuesday actually
Tuesday हाँ ठीक है Tuesday
Mr. Ashok Kumar Mishra.
ऐसी रात था
And counselor pleading for the on the prayer of the Grand Council for both the parties. Please this matter on 12th of November 2024.
मतलब
अपन भी यदि
I'm so sorry Melody, I should have done it. I should have done it. Actually my
वाकम से थी अच्छी सुविधा करे पर चैम्बर देखिवा ପାଇଁ ଆପଣଙ୍କର ପେନ୍ ଡ୍ରାଇଭ ରେ ନେଇ ଗଲେ
हाँ पेन ड्राइव देला से दे दी मतलब
mention my little item 30. Just
you are not there, we passed it over. What do you want?
let it come on Monday. I'm not too well that
all the rest of the matter will come on Monday.
Okay. Also with permission.